Hello, this is attorney Jeremy Hogan and welcome to Legal Briefs. This week, the Chauvin case here in the US of A was wrapping up. We will likely have a verdict next week. If you recall, police officer Derek Chauvin knelt on George Floyd's neck and Chauvin declined to testify this last week, citing the Fifth Amendment to the US Constitution. Today, I'm going to tell you what that is all about, why you aren't required to testify against yourself, and why a lawyer might often tell a client not to testify at trial.
How has your mental health been affected by your previous incarceration?
I am a homicidal maniac.
So last week, former police officer Derek Chauvin declined to testify at his own trial, invoking his Fifth Amendment right against self-incrimination. He was charged with second-degree murder. Now that's an intentional killing. Third-degree murder, that's a killing with a depraved mind. That's like selling someone laced heroin and they die from an overdose. And lastly, he was charged with manslaughter, which is an accidental but negligent killing, kind of like if you're driving 105 miles per hour on the freeway, you crash and the other person dies. So that's the three charges. These three charges against the police officer stemmed from his kneeling on Mr. Floyd, something like this, for 9.5 minutes. Now, over the 2-week trial, there were a number of witnesses, a lot of witnesses, but when it came time for the defendant himself to testify...
Have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
And that is the proper way to phrase it. You don't plead the Fifth, because to plead something is to say it. Instead, you invoke your rights contained in the Fifth Amendment, and then this is what will happen after that. The judge will give this instruction to the jury.
The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case.
American law proposes a very high burden on the government before the government can imprison a person or punish a person for a crime. Specifically, that means that the accused is presumed innocent until the government can prove guilt beyond a reasonable doubt. So it's the government's job to prove its case. It's not the job of the accused to defend himself or herself. So technically, an accused could just sit there at the table and not say a word and is still presumed innocent until the government can prove its case, and his choice not to testify cannot be used against him. And the United States is not alone in this. 108 countries out of 150 some countries in the world have some form of this rule. Even China recently has got on board with it. And it generally stems from the English common law and the protection against self-incrimination found in the common law. And the common law rule was a reaction to the way the English government had gone about prosecuting individuals and obtaining confessions and such. Now, I was able to go back in time and actually find some video of an older English police interrogation, and here it is.
Down!
Tell us the truth.
About what? I don't know what you want!
I want the truth.
I miss Game of Thrones. In any case, that was the origins of the Fifth Amendment. It was a response to certain old school tactics to obtain confessions. So knowing that, why do defendants nowadays often invoke the Fifth Amendment? Now, the cynical view to this, although perhaps true, is that they don't testify because they are guilty. And certainly that plays a part. But also, we don't want to put our client on the stand because it takes the focus off of whether the government has proven its case and instead turns the focus onto whether they believe the accused, whether they think he's a nice person or whatever. So the case is, it's not supposed to hinge on whether the jury feels that the accused is a bad person or whether it's believable, but whether the government has proven its case. Now, some defendants can and do save themselves by testifying, but that's usually because the evidence is so overwhelming, they have no choice, and it's really kind of a Hail Mary pass. Now, if you think back to the O.J. Simpson trial, at the time, O.J. was a loved persona. He was good-looking, charismatic, and even then he didn't testify in his own defense because the dangers are just too great that you will say something under cross-examination that will really hurt your case. So yes, O.J. tried on the glove and all that, but that fell under the demonstrative evidence and it's not really testimony. You know, the best part about watching Cochran's closing argument nowadays is that I watch the audience members, they are in awe, absolutely mesmerized by him, and that was a real talent.
If it doesn't fit, you must acquit.
Now the problem with Chauvin testifying is that he wouldn't have much to add to his defense because everything in the case is really on the video. He couldn't get up on the stand and raise his right hand and say, "Wasn't me." So the only purpose of putting Chauvin on the stand would be to make the jury like him, because the video is not very good for him. You'd have to put him on and have him say something like, "I'm sorry this happened. I only wanted to restrain him. I certainly didn't mean to hurt him." So my take on it is that the defense team coached him what to say, had someone cross-examine him a couple times, and he just didn't come across well. And then you, as his legal team, decide that he adds nothing to his defense because he can't add to the medical testimony, and what he did is all on video. So with that, you have to make the decision for him to invoke the Fifth and not testify. So the defense will obviously go all in on the medical causation defense. That's what they're hanging their hat on. Now, what do you think the verdict will be? Let me know. Let me know in the comments. Second degree, third degree murder, manslaughter, or even not guilty. Thanks for watching, and remember, even in life, sometimes it's better if you remain silent if you have nothing constructive to add.